Question 1. In a high-stakes environment where multiple challenges arise in interpreting legal precedent, an attorney is tasked with crafting a persuasive appellate brief. The attorney relies heavily on an older Supreme Court ruling that appears to support their client's position. However, opposing counsel argues that subsequent decisions have significantly narrowed the applicability of that precedent. The attorney must determine whether to cite the original ruling as by authority or as persuasive authority. What is the most appropriate approach in this scenario? A. Cite the original ruling as binding authority without considering subsequent decisions, as Supreme Court rulings are always controlling. B. Argue that the original ruling remains binding and ignore opposing counsel's argument about narrowing applicability. C. Analyze subsequent cases to determine whether they have effectively overruled or distinguished the original ruling before citing it as binding authority. D. Avoid citing the original ruling altogether to prevent weakening the brief's persuasive power. Answer. C. Analyze subsequent cases to determine whether they have effectively overruled or distinguished the original ruling before citing it as binding authority. Explanation. In legal research and writing, it is critical to understand the doctrine of stare decisis and the role of precedent in appellate advocacy. The attorney cannot assume that a prior Supreme Court decision remains controlling without assessing whether it has been overruled, distinguished, or limited. So by later rulings, courts apply precedent based on how it has evolved over time, and failure to recognize subsequent interpretations could weaken an argument or even be considered misleading. Option is incorrect because while Supreme Court rulings are the highest legal authority, their applicability depends on later interpretations. Option B is incorrect because ignoring the opposing argument would demonstrate a lack of legal analysis. Courts expect attorneys to acknowledge and distinguish cases appropriately. Option D is incorrect because the original ruling might still hold persuasive value even if it is no longer binding. Omitting it entirely might weaken the argument unnecessarily. Attorneys should shepherdize or key cite their cases using legal research tools like Westlaw or LexisNexis to ensure they are citing good law. Question 2. While analyzing the root causes of sequential problems in statutory interpretation, a judge is tasked with resolving a dispute over the meaning of a vague term in a state statute. The state legislature has not provided a definition, and the legislative history offers conflicting interpretations. The judge must determine the most appropriate method to resolve the ambiguity. Which of the following approaches is most aligned with legal principle? A. Use the plain meaning rule and interpret the statute exactly as written, even if it leads to absurd results. B. Apply the doctrine of adjustum generis to interpret the term in the context of surrounding words in the statute. C. Defer to the executive agency responsible for enforcing the statute without conducting independent analysis. D. Create a new legal test to determine the statute's meaning based on policy considerations. Answer. B. Apply the doctrine of adjustum generis to interpret the term in the context of surrounding words in the statute. Explanation. Statutory interpretation is a critical skill in legal analysis, and courts use established canons of construction to resolve ambiguities. The doctrine of adjustum generis is a widely accepted interpretive tool that provides that when a general term follows a list of specific terms, the general term should be interpreted in the context of the preceding specific terms. Option is incorrect because the plain meaning rule should not be applied if it leads to absurd results, as established in cases like Church of the Holy Trinity v. United States, 1892. Option C is incorrect because while courts may defer to agencies under Chevron deference, they are not required to do so if the statute does not explicitly delegate interpretation authority. Option D is incorrect because courts do not create legal tests based purely on policy considerations without grounding them in legal precedent or statutory framework. A judge using adjustum generis ensures the interpretation remains consistent with the statutory scheme while avoiding overly broad or unintended applications. Question 3. During a comprehensive review of a process that needs improvement in legal citation, a law student is drafting a memorandum and needs to correctly cite a case following the Blue Book. A uniform system of citation. The case in question is United States v. Smith, decided in 2021 by the U.S. Court of Appeals for the Ninth Circuit and found at volume 987 of the Federal Reporter, 3rd Series, page 456. Which of the following is the correct citation format for the first full citation of this case in the memorandum? A. United States v. Smith, 987 F.3 456, 9th Sir, 2021. B. U.S. v. Smith, 987 F.3 456 Ninth Circuit 2021. C. United States v. Smith 987 Fed. Ax 456 Ninth Circuit 2021. D. United States v. Smith 987 F. 3 456 2021. Answer A. United States v. Smith 987 F.3 456 9th Sir 2021. Explanation. Legal citation follows strict Blue Book rules, which require the proper format for case names, reporters, court designations, and year of decision. Option A is correct because case name. To United States v. Smith, correct spelling and italicization. Reporter citation 987 F.3 456. 987 is the volume number, F.3 refers to the Federal Reporter 3rd series, and 456 is the page number, court and year. 9th Sir 2021. 9th Sir is the correct Blue Book abbreviation for 9th Circuit. Option B is incorrect because U.S. v. Smith is an improper abbreviation under Blue Book rules, and 9th Circuit should be abbreviated as 9th Sir. Option C is incorrect because Fed. Ax is used for unpublished opinions, not published Federal Reporter cases. Option D is incorrect because F. 3 is improperly spaced and the court is missing from the citation. Proper citation ensures clarity and credibility in legal writing. Law students should always refer to the latest edition of the Blue Book and use tools like Westlaw's KeyCite to verify citations. Question 4. In a situation where formal requirements conflict with practical application, a junior legal researcher is tasked with finding the most authoritative case law to support a client's argument in a complex contractual dispute. The researcher must consider the hierarchy of legal authority, precedent, and the role of persuasive sources. However, they discover that the only binding precedent is outdated and has since been criticized in multiple opinions, though not expressly overturned. The opposing counsel has cited more recent persuasive authority from a different jurisdiction that aligns with current trends in contract interpretation. The researcher must decide how to structure their argument while adhering to principles of stare decisis. Which of the following approaches would be the most legally sound? A. Rely solely on the binding precedent, as it remains technically valid, and ignore the opposing counsel's persuasive sources since they are from another jurisdiction. B. Acknowledge the binding precedent but argue that its reasoning is no longer persuasive by highlighting the recent appellate decisions that have criticized it while also introducing the opposing counsel's persuasive authority as supporting evidence. C. Disregard the binding precedent entirely. Construct the argument based on the opposing counsel's persuasive authority, given that it aligns with modern contract law principles. D. Ignore all case law and instead base the argument on general principles of equity and fairness, since contract disputes are often resolved on such grounds. Answer B. Acknowledge the binding precedent but argue that its reasoning is no longer persuasive by highlighting the recent appellate decisions that have criticized it while also introducing the opposing counsel's persuasive authority as supporting evidence. Explanation. In legal research, the hierarchy of authority dictates that binding precedent must be followed unless overruled. However, if precedent has been repeatedly criticized, its persuasive value diminishes. The best strategy is to acknowledge the binding precedent but argue for more modern interpretation by leveraging persuasive authorities, especially if appellate courts have signaled shift in legal reasoning. Ignoring binding precedent altogether, option C, could weaken the argument as courts expect litigants to engage with existing case law rather than disregard it. Likewise, relying solely on an outdated precedent, option A, risks weak argument. Judge is inclined to follow more recent trends. Finally, option D is incorrect because courts require legal authority rather than abstract principles of equity when interpreting contracts. Question 5. During an emergency response where multiple areas are impacted by a new regulation, a legal research team must quickly determine how administrative agencies are interpreting a recent federal law affecting environmental compliance. The team finds conflicting interpretations across various agency guidance documents, administrative law rulings, and judicial decisions. Which research method would be the most effective in determining how courts are likely to rule on a pending case involving this regulation? A. Reviewing only the agency's official guidance documents and rulemaking commentary, as agencies have the most expertise in interpreting their own regulations. B. Conducting case law research to find judicial decisions that have addressed similar regulations and analyzing how courts have ruled on agency interpretations. C. Relying primarily on secondary sources such as legal encyclopedias and law review articles to get perspective on the issue before looking at primary sources. D. Using shepherdizing, LexisNexis or KeyCite, Wessel, to check whether agency interpretations have been cited in judicial decisions and whether they have been upheld or overturned. Answer: D. Using shepherdizing, LexisNexis or KeyCite, Westlaw to check whether agency interpretations have been cited in judicial decisions and whether they have been upheld or overturned. Explanation: while agencies have authority in interpreting their own regulations, option A, courts ultimately decide whether an agency's interpretation is consistent with statutory law. Therefore, looking at how courts have ruled on similar issues, option B is. However, the most efficient way to determine how regulation is currently being treated in courts is by using data services like shepherdizing or KeyCite, option D, which provide an up-to-date status on whether agency interpretations have been upheld, modified, or rejected. Option C is useful but preliminary step, as secondary sources offer summaries rather than controlling authority. Question 6. While analyzing the root causes of sequential problems in legal citation, a law student struggles with understanding proper Blue Book citation for cases that have multiple parallel citations, including federal and state reporters. The student must correctly format the citation for a case that was decided in the U.S. Supreme Court but originally heard in a state Supreme Court. Which of the following citations follows correct Blue Book format? A. Smith v. Jones 567 U.S. 234 245 2020 120 S. CT 567 574 2020. B. Smith v. Jones 567 U.S. 234 2020. C. Smith v. Jones 120 S. CT 567 2020. D. Smith v. Jones 567 U.S. 234 2020. Sir. Granted 120 S. CT 567 2019. Answer: B. Smith v. Jones 567 U.S. 234 2020. Explanation: the proper way to cite a U.S. Supreme Court case under Blue Book rules is to use the official U.S. reporter citation if available. Option B. Parallel citations to S.C.T. Supreme Court reporter or L.Ed. Lawyer's edition are unnecessary unless required by specific jurisdictional rules. Option A is incorrect because it provides redundant citations. Option C is incorrect because it cites only the Supreme Court reporter rather than the official U.S. reporter. Option D is incorrect because granted is used only when citing a lower court decision that is under review, not for a case that has been decided. Question 7. In an environment where different components must interact in a legal research memorandum, an attorney is drafting an internal memo for a law firm evaluating the likelihood of success in a product liability case. The attorney must apply RAC issue, rule application conclusion methodology effectively. Which of the following best demonstrates correct legal memo organization under IRAC? A. Begin with a discussion of relevant legal principles, then analyze the facts of the case, conclude with a summary and introduce the issue at the end. B. Introduce the issue first, then state the rule of law, apply the law to the facts of the case, and conclude with the attorney's recommendation. C. Provide summary of possible arguments for both sides, then conclude with neutral statement without applying the rule to the facts. D. Start with narrative of the case, then provide statutes and legal precedents without explicitly applying them to the facts. Answer B. Introduce the issue first, then state the rule of law, apply the law to the facts of the case, and conclude with the attorney's recommendation. Explanation: the IRAC method requires clear structure. 1. Issue. Clearly state the legal question being analyzed. 2. Rule. Present the relevant law, including statutes, case law, and principles. 3. Application. Apply the rule to the specific facts of the case, analyzing how the law enters the given scenario. 4. Conclusion. Provide well-reasoned answer or prediction. Option is incorrect because the issue must be stated upfront. Option C is incorrect because legal memo must apply the law to the facts rather than just listing arguments. Option D is incorrect because legal analysis must explicitly connect legal authority to the case at hand. Question 8. In a multi-location scenario where consistency requirements vary, a legal researcher is tasked with analyzing statutory construction principles to determine how a newly enacted state consumer protection statute applies to different businesses operating across multiple jurisdictions. The statute contains ambiguous language, and conflicting interpretations have emerged among state courts. Some courts favor a strict textualist approach while rely on legislative history and public policy considerations. The researcher must provide a memorandum advising a corporate client on the best compliance strategy. Which of the following approaches is the most legally sound? A. Adopt the strict textualist interpretation, ensuring compliance with the narrowest possible reading of the statute, even if some jurisdictions have adopted a more expansive interpretation. B. Follow the broadest interpretation of the statute to minimize litigation risk, even if some jurisdictions have not yet ruled on the issue. C. Conduct a jurisdiction-by-jurisdiction analysis assessing how each state court has ruled and take compliance strategies accordingly, while noting any trends in statutory interpretation. D. Disregard judicial interpretations and instead rely exclusively on the legislative history and policy statements from lawmakers as they reflect the intended purpose of the law. Answer. C. Conduct a jurisdiction-by-jurisdiction analysis assessing how each state court has ruled and tailoring compliance strategies accordingly, while noting any trends in statutory interpretation. Explanation. The most legally sound approach is to conduct a jurisdiction-by-jurisdiction analysis, option C, which ensures that the client adheres to binding precedent in states where courts have ruled while remaining flexible in jurisdictions where interpretations remain uncertain. Statutory construction involves multiple interpretive tools, including textualism, legislative intent, and precedent. Courts may apply different methods, and a one-size-fits-all compliance approach could expose the client to legal risk. Following a strict textualist approach, option A, may not be advisable in jurisdictions that favor broader interpretations. Likewise, adopting the broad interpretation, option B, could impose unnecessary burdens if some states favor a narrower view. Lastly, relying solely on legislative history, option D, is problematic because courts prioritize statutory text and precedent over non-binding legislative commentary. Question 9. During a comprehensive review of a process that needs improvement, a legal research team is asked to analyze the role of administrative law in shaping workplace safety regulations. The team discovers that a federal agency has issued a controversial rule expanding employer liability for third-party contractor injuries. Some legal scholars argue the rule exceeds the agency's statutory authority, while others contend it is exercise of delegated rulemaking power. Which argument would be most persuasive under the Chevron deference doctrine? A. The agency's rule should be upheld because it is within the agency's expertise, and courts must defer to administrative agencies on all regulatory interpretations. B. The rule should be upheld only if the statutory language is ambiguous and the agency's interpretation is reasonable, following the two-step Chevron deference framework. C. The rule should be struck down because agencies lack independent lawmaking authority and can only enforce statutes as written with no interpretative discretion. D. The rule should be automatically invalidated if challenged in court, as courts must have the final say in all statutory interpretations. Answer. B. The rule should be upheld only if the statutory language is ambiguous and the agency's interpretation is reasonable, following the two-step Chevron deference framework. Explanation. Under the Chevron deference doctrine, courts apply two-step tests when reviewing an agency's interpretation of statute. First, the court determines whether the statute is ambiguous. If the language is clear, the court must apply the plain meaning and not defer to agency. If the statute is ambiguous, the second step requires the court to assess whether the agency's interpretation is reasonable. If reasonable, courts will defer to the agency's judgment. Option A is incorrect because courts do not defer to agencies in all cases, only when statutory ambiguity exists. Option C is incorrect because agencies do have interpretative discretion when Congress delegates authority, and courts recognize agency expertise in complex regulatory matters. Option D is incorrect because courts do not automatically override agencies, but rather they apply the Chevron test. Chevron deference plays a critical role in administrative law, particularly when agencies implement and enforce workplace safety regulations, environmental rules, and financial regulations. Understanding this doctrine is essential for legal professionals navigating regulatory compliance and administrative litigation. Question 10. In an environment where different components must interact, a legal team is drafting an appellate brief in a constitutional law case challenging a state statute that restricts political protests in certain public spaces. The statute has been upheld in lower courts under time, place, and manner restrictions. However, recent U.S. Supreme Court decisions suggest a more protective approach to public forum doctrine. Which argument is most likely to persuade an appellate court to strike down the statute? A. The statute is unconstitutional because all restrictions on political speech in public spaces violate the First Amendment. B. The statute must be struck down because it imposes content-based restrictions on speech and fails strict scrutiny. C. The statute should be invalidated because it applies neutral, content-based restrictions that are overly broad, making it unconstitutional under the overbreadth doctrine. D. The statute should be up because states have broad authority to regulate speech in public spaces to maintain order and safety. Answer. B. The statute must be struck down because it imposes content-based restrictions on speech and fails strict scrutiny. Explanation. The strongest constitutional argument is that the statute imposes content-based restrictions on speech and therefore fails strict scrutiny. Option B. Under First Amendment jurisprudence, courts distinguish between content-based and content-neutral restrictions on speech. Content-based laws regulate speech based on its message and must satisfy strict scrutiny, meaning the government must show that the law is narrowly tailored to achieve a compelling governmental interest. Content-neutral laws, e.g., time, place, and manner restrictions, are subject to intermediate scrutiny and must be tailored to serve a significant government interest while leaving open alternative channels for expression. Option A is incorrect because not all restrictions on political speech in public spaces are unconstitutional. Many are allowed if they meet legal standards. Option C is incorrect because while overbreadth is valid doctrine, the stronger argument in this case is that the law discriminates based on content, requiring strict scrutiny. Option D is incorrect because although states can regulate speech for public order, they cannot impose content-based restrictions without meeting strict scrutiny. Question 11. When considering ways to enhance a legal research strategy, a law firm is evaluating the reliability of secondary sources. The firm is preparing a high-stakes litigation brief where the accuracy of cited legal principles is critical. Which of the following secondary sources is most authoritative and should be prioritized when interpreting a novel legal issue? A well-respected legal treatise written by a leading scholar in the field. B. A recent blog post by a practicing attorney analyzing a court decision. C. An unpublished law review article discussing theoretical implications of a new statute. D. A social media post summarizing a Supreme Court ruling. Answer. A well-respected legal treatise written by a leading scholar in the field. Explanation. In legal research, secondary sources provide commentary and analysis of the law, but they are not binding authority. However, some are more persuasive than others. Legal treatises, option A, are among the most authoritative secondary sources, especially when written by a leading scholar in the field. They provide comprehensive analysis, citations to sources, and are frequently cited by courts. Blog posts, option B, and social media summaries, option D, lack formal legal rigor, peer review, and reliable citations, making them less authoritative. Law review articles, option C, can be persuasive, but unpublished or highly theoretical articles may lack the practical analysis needed for high-stakes litigation. For complex or novel legal issues, prioritizing well-respected treatises, restatements of law, and judicial opinions ensures accuracy and reliability in legal arguments. Question 12. During a comprehensive review of a process that needs improvement, a legal researcher is asked to determine how courts apply the doctrine of judicial notice in evidentiary rulings. Which of the following is the best example of a fact that a court would take judicial notice of under the federal rules of evidence? A. The opinion of a forensic expert on the cause of death in a homicide case. B. The official inflation rate published by the U.S. Bureau of Labor Statistics. C. A statement made by a party in a prior lawsuit that contradicts their current testimony. D. The projected future revenue of a publicly traded company based on expert analysis. Answer. B. The official inflation rate published by the U.S. Bureau of Labor Statistics. Explanation. Judicial notice allows courts to accept certain facts as true without requiring formal proof, but only if they are not subject to reasonable dispute because they are generally known within the court's jurisdiction, easily verifiable from sources whose accuracy cannot be reasonably questioned. E.g., government reports, official records. Option B is correct because government published economic data meets both criteria. Option A is incorrect because expert opinions require formal testimony and can be disputed. Option C is incorrect because parties' statement must be introduced as evidence rather than being judicially noticed. Option D is incorrect because financial projections are speculative and subject to interpretation. Understanding judicial notice is critical in evidentiary law as it allows litigators to introduce certain facts without unnecessary procedural hurdles. Question 13. In an environment where multiple sources of law must be reconciled, an attorney is researching a conflict between a federal regulation and a state statute regarding environmental compliance requirements. The federal regulation establishes stricter pollution control standards than the state law. Under the Supremacy Clause of the U.S. Constitution, how should the attorney determine which law applies? A. The state law applies because states have primary authority over environmental regulations. B. The federal regulation applies because it preempts the state law under the Supremacy Clause. C. The state law applies if it was enacted before the federal regulation. D. The stricter standard applies only if explicitly approved by both state and federal authorities. Answer: B. The federal regulation applies because it preempts the state law under the Supremacy Clause. Explanation: the Supremacy Clause, Article Omens Clause 2 of the U.S. Constitution, establishes that federal law takes precedence over conflicting state law. If a federal regulation imposes stricter environmental standards, it preempts the state law unless the federal law allows states to enact stricter regulations. The state law does not conflict with the federal requirement. Option A is incorrect because while states regulate environmental law, they cannot override federal mandates. Option C is incorrect because the order of enactment does not determine supremacy. Conflict does. Option D is incorrect because explicit approval from both levels of government is unnecessary for preemption to apply. Understanding preemption doctrine is crucial in cases involving federal versus state regulatory conflicts. Question 14. A law firm is conducting statutory interpretation research regarding a recently enacted tax law. The firm finds that the statute is ambiguous and there are conflicting interpretations from lower courts. According to established principles of statutory construction, which of the following sources is the most persuasive in resolving the ambiguity? A. A statement by a member of Congress who voted for the law but was not involved in drafting it. B. The legislative history, including committee reports and congressional debates. C. A press release issued by an executive agency explaining how the law should be applied. D. The personal opinion of the statute's sponsor on how the law should be enforced. Answer: B. The legislative history, including committee reports and congressional debates. Explanation: when courts interpret ambiguous statutes, they use statutory construction tools, including textual analysis, plain meaning rule, legislative history. Option B, such as committee reports, floor debates, and congressional findings, which are considered persuasive but not binding. Administrative interpretations, option C, may be relevant, are not primary unless granted deference. Option A is incorrect because a single legislator's view is not determinative. Option D is incorrect because the sponsor's personal opinion does not bind courts. Courts prioritize text and legislative history when resolving statutory ambiguities. Question 15. In the process of refining a contract drafting strategy, a corporate attorney is tasked with ensuring that a force majeure clause in a commercial lease agreement is enforceable under common law. Which of the following events is least likely to qualify as a force majeure event under traditional contract principles? A. A natural disaster that makes the leased property unusable. B. A government-imposed shutdown due to a public health emergency. C. A severe economic downturn that makes the contract financially burdensome. D. A war that prevents either party from fulfilling contractual obligations. Answer: C. A severe economic downturn that makes the contract financially burdensome. Explanation: a force majeure clause excuses performance due to extraordinary events beyond a party's control. Traditionally, force majeure covers natural disasters, option A; government actions, option B; war, political instability, option D. However, economic hardship, option C, is generally not valid force majeure defense because losses are foreseeable business risks rather than external, unforeseeable events. Understanding force majeure is crucial in contract drafting and litigation. Question 16. When conducting legal research on statutory interpretation, how should an attorney determine whether a statute should be read narrowly or broadly to achieve legislative intent? A. By relying solely on the plain meaning of the statutory language. B. By considering the legislative history and purpose of the statute. C. By deferring to the interpretation provided by a lower court, even if non-binding. D. By applying only a strict textualist approach without considering external sources. Answer. B. By considering the legislative history and purpose of the statute. Explanation. Statutory interpretation requires balancing textual clarity with legislative intent. Courts often apply the plain meaning rule first. Examine legislative history. Option B, when ambiguity exists. Consider judicial precedent, but lower court rulings, option C, are not always binding. Avoid rigid textualism, option D, when it leads to certain results. Question 17. In an environment where multiple legal authorities must be reconciled, what is the best method for determining whether a legal precedent has been overturned or modified? A. Reviewing case law annotations in a legal research database. B. Relying on the original case decision without checking subsequent citations. C. Checking a treatise written by a legal scholar. D. Searching for blog posts summarizing recent case developments. Answer. A. Reviewing case law annotations in a legal research database. Explanation. The most reliable method to verify case validity is using citators, e.g. key site shepherds, to track case history and determine if it has been overruled or distinguished. Relying solely on the original case, option B, risks missing later modifications. Treatises, option C, are secondary sources and may not reflect the latest rulings. Blog, option D, are often informal and unreliable. Question 18. To ensure a legal research strategy is comprehensive, which of the following is the most effective approach for identifying persuasive authority in a jurisdiction where there is no binding precedent? A. Searching for cases from other jurisdictions with similar legal issues. B. Relying only on statutes and ignoring case law. C. Limiting research to trial court decisions within the jurisdiction. D. Consulting only legal encyclopedias without reviewing judicial opinions. Answer. A. Searching for cases from other jurisdictions with similar legal issues. Explanation. When no binding precedent exists, courts often consider persuasive authority from other jurisdictions. Option A. Statutes. Option B. Must still be interpreted through case law. Trial court decisions. Option C. Are not binding and may lack thorough legal reasoning. Legal encyclopedias. Option D. Are useful but not authoritative. Question 19. When refining a legal writing process, what is the most effective strategy for drafting a persuasive appellate brief? A. Using only lengthy, complex sentences to demonstrate legal sophistication. B. Organizing arguments using the Iraq issue rule application conclusion method. C. Avoiding counter-arguments to maintain a strong position. D. Relying primarily on rhetorical appeals rather than legal precedent. Answer. B. Organizing arguments using the Iraq issue rule application conclusion method. Explanation. A persuasive appellate brief should follow a clear structure. Option B. Using Iraq or a similar framework, use clear, concise language. Option is incorrect. Address and refute counter-arguments. Option C is incorrect. Base arguments on legal precedent rather than emotional appeals. Option D is incorrect. Question 20. As part of a process improvement initiative, a law firm is evaluating best practices for citing legal sources. Which citation method is most appropriate for ensuring credibility in legal writing? A. Using informal footnotes instead of formal citations. B. Following the Blue Book citation format for court submissions. C. Omitting citations when the legal principle is widely known. D. Citing only secondary sources rather than primary law. Answer. B. Following the Blue Book citation format for court submissions. Explanation. In legal writing, citations must follow standardized rules. Option B, such as the Blue Book for courts or all for some legal documents. B. Formal. Option is incorrect. Be included even for well-known principles. Option C is incorrect. Prioritize primary sources. Option D is incorrect. Question 21. To ensure a process is legally compliant, what is the best way to verify whether a statute has been amended or repealed? A. Checking the latest official version of the statute in a government database. B. Relying only on older printed versions of the statute. C. Assuming the statute is still valid if no case has challenged it. D. Searching legal blogs rather than official legal sources. Answer A. Checking the latest official version of the statute in a government database. Explanation: the most accurate way to verify statutory validity is checking an official government source. Option A. Printed versions. Option B may be outdated. A statute remains valid even if not challenged. Option C is incorrect. Legal blogs. Option D may be unreliable. Question 22. When considering ways to enhance contract clarity, what is the best drafting technique to avoid ambiguity? A. Using precise defined terms and avoiding unnecessary legalese. B. Including vague terms to allow for flexibility in interpretation. C. Writing in long, complex paragraphs to demonstrate thoroughness. D. Using industry jargon without definitions. Answer A. Using precise defined terms and avoiding unnecessary legalese. Explanation: clear contract drafting requires precision and defined terms. Option A. Avoiding vague terms. Option B. That create disputes. Keeping sentences concise. Option C. Defining industry terms. Option D. For clarity. Question 23. In an environment where case law is constantly evolving, what is the best way to ensure a legal argument remains current? A. Regularly updating research with new case law using legal databases. B. Relying on precedent without checking for updates. C. Assuming statutes are always applied the same way over time. D. Using secondary sources instead of primary legal materials. Answer A. Regularly updating research with new case law using legal databases. Explanation: legal arguments must remain current by regularly checking for updates. Option A. Precedent. Option B. Can be overturned. Statutes. Option C. Are often reinterpreted. Primary sources. Option D. Take precedence over secondary sources. Question 24. During a comprehensive review of legal writing techniques, what is the most effective way to structure a persuasive legal memorandum? A. Start with a strong conclusion, then explain reasoning. B. Use headings and subheadings to clearly organize legal arguments. C. Write in a stream of consciousness, style to capture all thoughts. D. Avoid case citations and rely on general legal principles. Answer B. Use headings and subheadings to clearly organize legal arguments. Explanation: a persuasive legal memorandum should use clear organization. Option B. Follow Iraq or Creek structure. Be structured logically, not randomly. Option C. Include case citations. Option D. Question 25. To ensure legal compliance in a memorandum, which of the following best demonstrates proper ethical legal research practices? A. Citing sources accurately and avoiding misrepresentation of case law. B. Selectively citing cases that support the argument while ignoring contrary authority. C. Using unpublished, unverified sources without proper attribution. D. Relying on non-legal sources instead of primary legal authority. Answer A. Citing sources accurately and avoiding misrepresentation of case law. Explanation: ethical legal research requires accurate citations. Option A. Acknowledging counter-arguments. Option B is incorrect. Using verified sources. Option C is incorrect. Prioritizing primary sources. Option D is incorrect. Question 26. During a critical transition period where existing processes must be adapted to comply with new statutory requirements, a legal researcher is tasked with analyzing legislative history to determine congressional intent. Which of the following is the most authoritative source to rely on for understanding legislative intent? A. Committee reports issued by Congress. B. Floor statements made by individual legislators. C. Newspaper articles discussing the passage of the statute. D. Legal treatises summarizing statutory interpretation principles. Answer A. Committee reports issued by Congress. Explanation: committee reports are the most authoritative source of legislative intent because they provide official documentation on the purpose and meaning of statutory provisions, while floor statements, option B, may be informative. They are not as reliable since they often reflect individual opinions rather than legislative consensus. Newspaper articles, option C, and legal treatises, option are secondary sources and do not carry legal weight in statutory interpretation. Legal rule: courts frequently rely on committee reports, bill drafts, and hearing transcripts when interpreting ambiguous statutes. See Chevron U.S. Inc. for RDC 467 U.S. 837 1984. Question 27. In a multi-location scenario where consistency requirements must be maintained across jurisdictions, an attorney is conducting legal research to compare conflicting state statutes on contract formation. Which resource would provide the most comprehensive and structured comparison of different state laws? A. Restatements of the law. B. A legal encyclopedia like American jurisprudence. C. A Shepard's or Keysight report. D. The Federal Register. Answer: A. Restatements of the law. Explanation: Restatements of the law, option A, published by the American Law Institute, OLLI, provide authoritative summaries of legal principles across different jurisdictions and are highly persuasive in courts. Legal encyclopedias, option B, provide general overviews, but are not designed for direct jurisdictional comparisons. Shepard's and Keysight, option C, are used for case law citation tracking. Statutory comparison: the Federal Register, option D, only applies to federal regulations, not state statutes. Legal rule: courts and practitioners rely on restatements of the law to clarify and unify legal doctrines in areas such as contracts, torts, and property. Question 28. When implementing new protocols in a shared environment, a law firm is drafting a memorandum analyzing whether an administrative agency's interpretation of its own regulation is entitled to deference. Which legal doctrine is most relevant in this context? A. The Chevron deference doctrine. B. The Erie doctrine. C. The parallel evidence rule. D. The best evidence rule. Answer: A. The Chevron deference doctrine. Explanation: The Chevron deference doctrine, Chevron U.S. A. Inc., the ADC 467 U.S. 837, 1984 applies when courts review an agency's interpretation of statute it administers. If the statute is ambiguous, courts defer to the agency's reasonable interpretation. The Erie doctrine, option B, governs federal versus state law conflicts in diversity cases. The parole evidence rule, option C, applies to contract disputes, and the best evidence rule, option D, governs admissibility of document evidence. Legal rule: under Chevron Step 1 and Step 2, courts ask whether Congress spoke clearly on the issue and, if not, whether the agency's interpretation is reasonable. Question 29. During an emergency response where multiple areas are impacted, a law clerk is researching the constitutional limits of federal emergency powers. Which constitutional provision primarily grants Congress the authority to enact emergency legislation? A. The Commerce Clause. B. The Necessary and Proper Clause. C. The Privileges and Immunities Clause. D. The Takings Clause. Answer: B. The Necessary and Proper Clause. Explanation: The Necessary and Proper Clause, Article I, Section 8, Clause 18, grants Congress the power to pass laws essential to executing its enumerated powers, including emergency legislation such as the Defense Production Act and disaster relief statutes. The Commerce Clause, option A, allows Congress to regulate economic activity but is not the primary basis for emergency powers. Privileges and Immunities Clause, option C, applies to interstate discrimination issues, and the Takings Clause, option D, concerns government seizure of private property with compensation. Legal rule: the Necessary and Proper Clause has been interpreted broadly. McCulloch v. Maryland, 17 U.S. 316, 1819, to justify federal emergency actions. Question 30. While analyzing the root causes of sequential problems in legal citation errors, a law student struggles with properly citing state statutes in a legal memorandum. According to the Blue Book, which of the following elements is always required when citing a state statute for the first time in a legal document? A. The name of the statute, the official code citation, and the year. B. The full legislative history of the statute, including amendments. C. A direct quote from the statute to provide context. D. Parallel citations to both state and federal versions of the statute. Answer: A. The name of the statute, the official code citation, and the year. Explanation: under Rule 12 of the Blue Book, the first citation to a state statute must include the official name of the statute, if applicable, the official code citation e.g. Cal. Civ. Code SS 1549, 2023, the year of the code volume or online publication. Legislative history, option B, is only required when interpreting ambiguous statutes. Direct quote, option C, is sometimes useful but not always required. Parallel citations, option D, are not mandatory unless specified by court rules. Legal rule: courts and legal professionals follow the Blue Book 21st ed. citation rules to ensure uniformity and clarity in legal documents.